Thank you for your interest in learning more about the proposed changes to the standards that govern the denial, suspension, and revocation of criminal justice certifications in Oregon. The purpose of this training is to review the recommended changes to the standard, including how and when DPSST professional standards cases are initiated, the process for which conduct is reviewed and what is considered during that review, and what happens when there is a decision to deny, revoke, or suspend public safety certifications. We will also briefly cover the administrative rule process, including how to submit public comment. The length of this presentation is approximately 33 minutes. At the end of this presentation, there will be an opportunity to submit an email to DPSST to have this training event added to your DPSST training record. There will also be information on where to send additional questions or to submit official public comment regarding the recommended changes. As you may be aware, the Department of Public Safety Standards and Training, more commonly known as DPSST, and its governing Board on Public Safety Standards and Training, exists to promote excellence in public safety by delivering quality training and developing and upholding professional standards for the nearly 42,000 providers of public safety services in the state of Oregon. In short, DPSST and BPSST exist to ensure Oregon's public safety providers are competent, capable, and remain above reproach to foster public trust. To meet this mission, the Oregon Legislature granted the Board the authority to establish the minimum physical, emotional, intellectual, and moral fitness standards that are required to be met prior to the award of a public safety certification. The Board also has the authority to establish standards that dictate when and how public safety certifications may be lost for a failure to meet or maintain the established standards. Please be aware that the standards being discussed in this presentation are limited to the disciplines that fall within the DPSST criminal justice family. Those disciplines include police officers, corrections officers, parole and probation officers, telecommunicators or 911 operators, emergency medical dispatchers, regulatory specialists for the Oregon Liquor Control Commission, and the instructors of mandated criminal justice training courses. Over the last 5 years, DPSST, in consultation with the Board, has decertified nearly 400 individuals employed in these disciplines for failure to meet or maintain the Board's established moral fitness standards. That's an average just shy of 80 officers per year. DPSST also has an average of 120 professional standards cases pending at any given time. These numbers prove that the Board can and will revoke the certifications of public safety professionals who engage in any type of misconduct. However, the question now becomes, are the right individuals being decertified for the right reasons? As one would expect, Oregon standards governing public safety professionals have evolved over time and continue to evolve to meet the ever-changing legal landscape as well as adapt to societal and political expectations of providers of public safety in Oregon. In recognition of this and the need to constantly review standards to ensure they remain relevant and appropriate, DPSST received permission from the Board and its partnering corrections, police, and telecommunications policy committees to form a multidisciplined work group to review the moral fitness standards and the processes and procedures relating to the denial and revocation of public safety certification and to make recommendations for adjustments as needed. The goal when forming this work group was to ensure that all disciplines, ranks, and geographic locations were represented. Membership was expanded to include other interested parties with the approval of the Board Chair. The work group first met in December of 2015 and worked throughout 2016 to develop a multitude of recommended changes to these standards, all of which directly impact public safety certification. The remainder of this presentation will be highlighting these recommended changes, and will end by providing a brief overview of the administrative rule process and the steps that must occur prior to the adoption of any or all of these recommendations. The standards that govern the denial and revocation of criminal justice certification are located in Oregon Administrative Rule, Chapter 259, Division 008, Section 0070. Throughout this presentation, the standard currently in place will be presented in red, and the proposed standard presented in blue. A side-by-side comparison will be made throughout to ensure that the recommended changes are being highlighted. Current rule language, which is titled simply Denial Revocation, was adopted in 2008. Though there have been many minor changes to the rule since its adoption, the standards and processes have remained largely unchanged. The full text of the rule can be found by visiting DPSST's webpage, www.oregon.gov/DPSST. The title of the proposed rule has been expanded to include suspension. The reason for this will be discussed later in the presentation. The tentative effective date of this rule is April 1st, 2017. However, please know that this date is subject to the administrative rule process, which may delay or halt completely the implementation of these changes. The administrative rule process will also be discussed briefly at the end of this presentation. The full text of the proposed rule can also be found on DPSST's webpage. To begin this discussion, it's important to know that there are two types of disqualifying behavior with respect to public safety certification denial, revocation, or suspension. Mandatory disqualifiers, which is behavior that requires denial or revocation, and discretionary disqualifiers, which is behavior that may require the denial, revocation, or suspension of certifications. We'll start by discussing the types of conduct that will lead to mandatory denial or revocation. Oregon law requires the revocation of public safety certifications for individuals who have been discharged for cause from their employment as a public safety professional. It is important to note that what constitutes cause for certification purposes is not necessarily the same as what may constitute cause for employment purposes. As such, the board has adopted a definition of discharge for cause. Once it's determined that an officer has been discharged for cause for certification purposes, and all due process rights have been exhausted, certification revocations are permanent. Officers who have certification revoked as a result of being discharged for cause also remain ineligible to hold public safety certification in Oregon for any criminal justice discipline permanently. Under the current standard, a discharge for cause is any employer-initiated termination that involves dishonesty, disregard for the rights of others, gross misconduct, incompetence, or misuse of authority. Upon being notified that a public safety professional has been discharged for cause, DPSST staff will review the conduct and will determine whether the board's definition of discharge for cause has been violated. If so, revocation is required and proceedings will be initiated without further review. Cases in which the behavior that led to the discharge is unrelated to the board certification standards will be administratively closed. The proposed standard refines the board's definition of discharge for cause. First, the new definition requires that the conduct that led to the discharge occurred while the individual was acting under the color of office. Further, the proposed definition was amended to include particularly egregious behavior that includes deliberately obtaining false confessions, initiating false arrests, creation and use of false evidence, including false testimony, intimidation, brutality, corruption, or sexual abuse. Under the proposed standard, conduct leading to a discharge will be reviewed by DPSST staff. Discharges involving behavior that meets the proposed definition of discharge for cause will require revocation, and DPSST staff will initiate revocation proceedings without further review. All other discharges that potentially violate the board's moral fitness standards will be reviewed as a discretionary disqualifier, which will be explained in more detail in the coming slides. Again, if the reason for the discharge is unrelated to certification standards, the case will be administratively closed. Certain criminal convictions may also be considered mandatory disqualifiers for certification purposes. Please note that this standard and the standards that follow do not require that the conviction occur in Oregon. These standards apply to any conviction that may have occurred in any jurisdiction that, when compared to Oregon law, would constitute a criminal conviction. Under the current standards, DPSST is required to deny or revoke public safety certifications upon discovery of a conviction for any of the following: any felony offense, any offense involving the unlawful use, possession, delivery, or manufacture of a controlled substance, narcotic, or dangerous drug, any crime involving an element of domestic violence, or the conviction of a crime determined to involve an element of dishonesty or deceit. For a list of those crimes, please reference the current administrative rule OAR 259-008-0070, subsection 3A-D. Under the proposed standard, DPSST will continue to be required to deny or revoke certification upon discovery of a conviction for any felony offense or a crime involving the unlawful use, possession, delivery, or manufacture of a controlled substance, narcotic, or dangerous drug. DPSST will also be required to deny or revoke for convictions of any crime involving an element of domestic violence, including child abuse that is domestic in nature, and any conviction that either currently requires or previously required registration as a sex offender. Again, these are mandatory disqualifiers. Convictions of these types of crimes require denial or revocation under the current and proposed standards and would be handled administratively by staff with no further review. Also of note that in these situations a conviction is required. Criminal behavior that results in anything less than a conviction in the court of law, deferred adjudications such as diversions, for example, would be handled as a discretionary disqualifier, which will be discussed next. Discretionary grounds for denial or revocation of public safety certifications are as follows. Under the current standard, the conviction of any criminal offense that is not considered a mandatory disqualifier. Again, please note the use of the word conviction here. Any non-voluntary separation from employment as a public safety professional, such as a resignation or retirement in lieu of termination or while under investigation. The falsification of any information submitted to DPSST, the violation of minimum training standards or any other board standard, or a police officer's failure to attend a session with a mental health professional following a situation involving a deadly use of force. Under the proposed standard, discretionary grounds include the conviction, violation, adjudication, entered plea of guilty or no contest, or a finding of guilt except for insanity of any criminal offense that is not considered a mandatory disqualifier, with the exception of successfully completed DUI diversions. Grounds also include any non-voluntary separation from employment as a public safety professional that violates the moral fitness standards, falsification of information, violation of a standard including academy standards, a police officer's failure to attend a session with a mental health professional, and, in very narrow situations, complaints filed with DPSST. Complaints will be discussed later on in this presentation. Interestingly enough, current administrative rule doesn't define moral fitness. Instead, it spells out what types of conduct constitutes a lack of moral fitness. Under the current standard, that is conduct that results in discretionary grounds for a certification review that involves dishonesty, disregard for the rights of others, misuse of authority, gross misconduct, or insubordination. Under the proposed standard, the conduct that results in discretionary grounds for a certification review involves dishonesty, disregard for the rights of others, misuse of authority, or gross misconduct. The definitions for these categories can be found in Administrative Rule. Listed are the definitions applicable under the current standard. The proposed standard makes some adjustments, including clarifying the definition and the elimination of the categories of misconduct and insubordination. The discretionary review process for both the current and proposed standards is as follows. Under the current standard, DPSST becomes aware of discretionary grounds for certification review. Remember, this may be a non-mandatory criminal conviction, a non-voluntary separation, falsification of information, violation of a board standard, or the failure of a police officer to attend a session with a mental health provider following the deadly use of force. DPSST staff will conduct a preliminary review of the conduct using investigatory materials made available by the arresting or investigating agency and will determine if, more likely than not, the board's certification standards may have been violated. In other words, that the conduct may fall into one or more of the categories discussed on the previous slides. If yes, the case will be presented to the Discipline-Specific Policy Committee for review and determination when considering all of the circumstances surrounding the conduct, including aggravating and mitigating factors, whether to recommend to the board that the individual's certifications be denied or revoked. This process has not changed with the recommendations found in the proposed standard. However, some of the methods with respect to how aggravation and mitigation are provided have. Under the current administrative rule, affected individuals are provided a copy of staff's preliminary findings that the board's moral fitness standards may have been violated. The affected public safety professional is then given 30 days to provide mitigation in writing, which may include anything they feel should be considered by the policy committee as they make their determination. This may include character references, performance appraisals, contradictory evidence, etc. That material becomes part of the staff report provided to the policy committee, unedited and in its entirety. The current rule also contains a list of factors that may be considered as mitigation. This list can be found in the current administrative rule, subsection 9D, and includes things like when the misconduct occurred or whether the public safety professional served jail time, etc. Under the proposed standards, the affected public safety professional will still be provided with a copy of staff's preliminary findings and will be given 30 days to provide written mitigation for the policy committee's consideration. The affected individual will also be given an opportunity to make arrangements with DPSST to provide mitigation verbally and in person to the policy committee. Verbal mitigation must be delivered in person, can be delivered by the affected individual or a representative of their choosing, and will be limited to 5 minutes. It's important to note that this will not be a question and answer session. The policy committee members will hear the mitigation presented and will move forward through their review process based on the information provided. One final change is that the list of mitigating factors found in the proposed rule must be considered by the policy committee. These include whether the conduct occurred before, during, or after the individual's employment in public safety, whether the individual has engaged in the same type of conduct more than once over a period of time, whether the conduct occurred while the individual was acting in their official capacity, whether the individual has previously been reviewed by a policy committee for prior conduct, whether the conduct involves elements of domestic violence or child abuse, whether the individual self-reported the conduct, and whether or not the conduct resulted in a criminal disposition. The complete list of mitigating factors that must be considered can be found in the proposed rule. Discretionary review process by a policy committee under the current standard is as follows. The policy committee considers the totality of the case and votes to recommend to the board to revoke or deny certifications or not revoke or deny certifications. If the decision is to revoke or deny, the committee then recommends a period of ineligibility, or the time period in which the individual will be ineligible to reapply for certification. Those recommendations go to the board, who affirms or denies the policy committee's recommendation. If the ultimate decision is to proceed with denial or revocation, the affected individual is afforded their due process rights under the Administrative Procedures Act. Under the proposed standard, this process has changed. First, you'll notice that the policy committee now has an option of recommending suspending certifications in addition to revoking and denying. Process-wise, the policy committee will still conduct a review based on the unique circumstances of each case. They will then determine whether or not the board's moral fitness standards have been violated. If no, they will recommend not denying or revoking certifications. If yes, however, they will determine how long of an ineligibility period is warranted. Obviously, if the determination is based on an application for training or certification, the recommendation will reflect how long the individual will remain ineligible to reapply for certification. If, however, an individual currently holds public safety certification, the recommended length of ineligibility will determine whether or not the individual's certifications will be revoked or suspended. Following these determinations, the board review process and due process rights have not changed. The ineligibility period ranges can be found in rule. The current rule spells out the ranges as follows. If the policy committee finds the conduct falls into one or more of the defined categories, they will recommend a time period based on the available range. If, for example, the officer is found to have engaged in misuse of authority, the policy committee can recommend an ineligibility period between 5 and 10 years. The proposed standards have been adjusted to reflect the proposed changes to the definitions. Again, if the policy committee review determines that an officer's conduct has violated one or more of the categories, they will use the following guidelines to determine the period of time the officer will be ineligible to hold public safety certification. Under the proposed standard, if the recommendation, after considering the totality of the circumstances, is to recommend an ineligibility period of any time between 3 and 5 years, the recommendation will be to suspend public safety certifications. Any recommended ineligibility period over 5 years will carry with it a recommendation to revoke certification. What happens following the expiration of an ineligibility period will change as well should the recommendations become adopted. Under the current standard, following the expiration of an ineligibility period, the individual must submit a request for an eligibility determination and can include documentation supporting this request. This request is reviewed by the policy committee, who will make a recommendation to the board on whether or not to restore an individual's ability to be certified. Please note that this does not mean that an individual's formerly held certifications are restored, only that any applications for future certifications will not be denied. To become recertified, the individual must be reemployed in a certifiable position and must meet all of the minimum standards for certification to include the training requirements. Under the proposed standards, certifications will be reactivated following the satisfaction of an ineligibility period in which certifications have been suspended. Also, an individual will be permitted to reapply for certification without the application being automatically denied following the satisfaction of an ineligibility period in which the certifications have been revoked. Under both of these circumstances, the individual will be required to be employed in a certifiable position and to meet all of the required minimum standards, including the minimum training standards, which may include recompletion of the basic training course. Also remember, the ability to become recertified does not negate the past behavior or decision of the board. The certification history will continue to reflect that certifications have been suspended or revoked, and the information surrounding those events will remain subject to public records law. With respect to timelines, under the current standard, DPSST is required to review mandatory disqualifiers regardless of when they occurred. However, DPSST may administratively close cases that don't meet the requirement for denial or revocation of public safety certification, cases that involve non-mandatory criminal convictions that occurred prior to January 1, 2001, and cases involving criminal convictions that only involve elements of misconduct, represent the only criminal conviction in the person's history, and occurred 7 years or more prior to the employment as a public safety professional. Under the proposed standard, DPSST will continue to be required to review situations involving mandatory disqualifiers regardless of when they occurred. The proposed standard gives the policy committee the discretion to administratively close all other cases in certain circumstances. DPSST may recommend administrative closure for cases that don't meet the requirement for denial, revocation, or suspension, cases that involve criminal convictions occurring prior to January 1, 2001, and criminal dispositions that occurred 7 years or more prior to employment, is the only criminal disposition in an individual's background. the conviction does not involve elements of dishonesty or deceit, and the individual is no longer on any form of court-ordered supervision and has satisfied all court-ordered restitution, fines, and fees. The work group has also recommended granting the board the authority to emergency suspend public safety certifications in extreme circumstances. In order to emergency suspend a public safety certification or certifications, the board must show a serious danger to the public health and safety. This is recognized as an extremely high threshold to meet. Individuals whose certifications have been suspended are prohibited from being employed as or performing the duties of a public safety professional. Another recommendation surrounds the requirement that DPSST be notified of arrests and convictions. The current standard requires that employed public safety professionals notify their department head upon conviction of a crime within 72 hours of being convicted. The department head then has the responsibility of notifying DPSST in writing within 5 business days. Under the proposed standard, all public safety professionals, whether they are employed or not, are responsible to report any arrest or criminal citation to appear to DPSST within 5 business days. Please note, this notification does not replace any responsibilities to report arrests or citations to your employer. Also of note, typically speaking, while DPSST will open a professional standards case upon notification of an arrest, DPSST will not take action until the criminal proceedings have concluded. Finally, DPSST will not initiate a professional standards case for an individual's failure to report an arrest or a citation as required by this standard. But this failure may be considered aggravation if and when the case is reviewed by a policy committee and the board. The work group has also recommended that every public safety professional complete 1 hour of ethics training annually. The content of this training is to be determined by the officer's employing agency. Failure to complete this training will result in an administrative suspension of certifications. Please note that this standard has been unanimously approved by the Telecommunications, Corrections, and Police Policy Committees and the Board. The standard is currently a recommended requirement, but will become required on January 1st, 2020. In an effort to increase transparency and legitimacy to the decisions being made at the policy committee level, the work group is recommending the filing of a legislative concept that will add a voting citizen member to the Telecommunications, Corrections, and Police Policy Committees. The citizen member must not be currently or formerly employed in any of the public safety disciplines overseen by the policy committee and must not be related by blood or marriage to someone who is employed in a public safety discipline. The recommendation allows the chair of the board to appoint the citizen member following a thorough background check. This recommendation was approved by the board to move forward as a legislative concept and will be presented to the members of the legislature during the 2017 session for consideration. Another change involves the voluntary relinquishment of certifications. Under the current standard, upon an individual's request to relinquish their certifications and waive a right to a hearing, DPSST will typically halt any administrative action. Under the proposed standard, officers may choose to surrender certifications, but that surrender will not become effective until it is accepted by the department. Prior to accepting a surrender, DPSST may continue an administrative investigation to complete its record. This change is being recommended to ensure that violations of moral fitness standards are recorded properly and to prevent someone who's violated the standard from being reemployed as a public safety professional. The final recommendation to be discussed involves how DPSST handles and processes complaints made against public safety professionals that fall within the board's jurisdiction. Under the current process, complaints received by DPSST are simply forwarded to the agency that employs the public safety officer, who is the subject of the complaint. Under the proposed process, complaints received by DPSST will still be forwarded to the employing agency for review and further investigation if needed. However, the proposed standard requires the agency responds back to DPSST that the complaint was received and reviewed, and that it was handled in a manner determined appropriate by the employing agency. DPSST will not initiate a professional standards case unless the complaint results in the non-voluntary separation or criminal conviction of a public safety professional. Complaints made against individuals who are no longer employed as a public safety professional, whose employing agency is non-responsive, or complaints made against an elected official will be presented to the Policy Committee for review and determination of next steps, up to and including the initiation of a DPSST investigation. Now that we've discussed all of the recommended changes, what happens next? The work group who developed these recommendations has concluded their work. The Telecommunications, Corrections, and Police Policy Committees have unanimously recommended the Board approve these recommendations at their respective meetings in November. On January 26, 2017, the Board unanimously approved the Policy Committee's recommendations to file the proposed administrative rule. The government agency, DPSST, is required by state and federal law to follow the administrative rule process, which requires that all of these recommendations be made available to all interested parties and that they be given an opportunity to provide comments for consideration. Should substantive public comment be received, these proposed changes in their entirety will be required to go back to the work group and the comments considered, and the process will begin again. That concludes this presentation about the recommended changes to the moral fitness standards. If you would like this training to appear on your DPSST training records, please email dpsstf6roster@state.or.us. Please title the email Moral Fitness Rule Changes and include your full name and DPSST number in the body of the email. Please remember that falsification of this information may subject your certifications to denial or revocation. Any questions, concerns, or comments, including comments pertaining to the recommendations discussed in this presentation, can be directed to DPSST's Professional Standards Division. On behalf of DPSST, BPSST, members of the Policy Committee, and the Work Group, we thank you for taking the time to familiarize yourself with what the recommendations are and how they will potentially impact the certification of Oregon's public safety providers. We encourage you to stay informed about the progress of these proposed changes by periodically visiting DPSST's website.